Okay, I'm quite behind on the Daf Yomi. So this is Daf 41 for Tractate Shevuot. So here we go. But the one who teaches it in reference to the latter clause maintains that specifically here, in this case, an oath of inducement is administered to the defendant as he admits that there is a matter of financial association between them. But there, in the case of the first clause, where the defendant maintains that the claim is baseless and there's no matter of financial association between them, the court does not administer to him an oath of inducement. So the Gemara asks, practically speaking, what difference is there between an oath administered by Torah law and an oath administered by rabbinic law? So an oath of inducement. The Gemara answers the practical difference between them is with regard to the transfer of an oath to the other party. In the case where the defendant suggests that instead of taking an oath himself, the claimant should take an oath and collect that which he claims. If the oath is administered by Torah law, we do not transfer the oath to the claimant. The defendant must either take an oath himself or pay. If the oath is administered by rabbinic law, we do transfer the oath. The Gemara asks, and according to Mar Bar Rav Ashi, who says that we transfer an oath that is administered by Torah law as well, what difference is there between an oath administered by Torah law and an oath administered by rabbinic law? The Gemara answers the practical difference between them is with regard to whether or not the court enters the property of the defendant to collect a payment if he refuses to take an oath. So with regard to an oath administered by Torah law, we enter his property, and with regard to an oath administered by rabbinic law, we do not enter his property. The Gemara asks, and what is the practical difference according to Rabbi Yossi, who says that even with regard to a debt that is owed by rabbinic law, we enter the property of the debtor to collect the debt. As we learned in a Mishnah, Gittin 59b, a lost item found by a deaf mute, an imbecile, or a minor is not acquired by him since he lacks the legal competence to effect acquisition. Nevertheless, taking such an item from him is considered robbery on account of the ways of peace. Although these individuals lack halakhic competence and are unable to acquire lost items by Torah law, taking such items from them is considered robbery. Rabbi Yossi says this is full-fledged robbery, and Rav Hista says that Rabbi Yossi means that it is full-fledged robbery by rabbinic law. Accordingly, what is the practical difference between the opinion of the first Tana and Rabbi Yossi's opinion there? The difference is that, according to Rabbi Yossi, if one refuses to return the stolen item, it is appropriated by the judges and returned to the one who found it. The Gemara completes its question. Since, according to the opinion of Rabbi Yossi, the court enters one's property to appropriate even an item that is owed by rabbinic law, what difference is there between an oath administered by Torah law and an oath administered by rabbinic law? The Gemara answers, the practical difference between them is with regard to a case where the one opposing the claimant, the defendant, is suspected with regard to oaths. With regard to an oath administered by Torah law, if the one opposing the claimant is suspected with regard to oaths, we transfer the obligation to take an oath and impose it on the other litigant, that is the claimant, who may take an oath and collect that which he claims be owed. With regard to an oath administered by rabbinic law, the court does not transfer the oath, as transference of an oath is by rabbinic ordinance. We do not institute one rabbinic ordinance upon another rabbinic ordinance. The Gemara asks, and according to the rabbis who disagree with Rabbi Yossi, as they say that with regard to an item that is owed by rabbinic law, we do not enter his property to collect the item. What do we do to one who refuses to take an oath of inducement? The Gemara answers, we excommunicate him until he takes an oath. Ravina said to Rav Ashi, this sanction is no less severe than entering his property and collecting the debt. It is like grabbing him between the legs and he surrenders his cloak. Rather, what do we do to him? Rav Ashi said to him, we excommunicate him until the time to flog him comes, that is 30 days. And if he refuses to take an oath or reach a settlement with the claimant, we flog him and then leave him alone. So Rav Papa said, with regard to one who produced a promissory note against another in court, and the defendant said to him, the debt in the note is already repaid, but for some reason I did not get the promissory note returned to me when I paid you. We say to the defendant, it is not in your power to deny the debt. Go pay. But the defendant said, let him take an oath to me that I did not repay him. We say to the claimant, take an oath to him. Rab Acha son of Rava said to Rav Ashi, but what is the difference between this case and the case of the one who vitiates his promissory note by acknowledging that he has received partial payment? In the latter case, the sages instituted that the creditor can collect the remainder of the debt only after taking an oath that he was not repaid more than the amount he admitted receiving. According to Rav Papa, an oath can be administered to any creditor who produces a promissory note, even if he did not vitiate it. So Rav Asi said to him, there, in the case of a creditor who vitiated his promissory note, even if the defendant does not himself make a claim demanding that the creditor take an oath, we, the court, make such a claim on his behalf. Here, in a case where the creditor did not vitiate his promissory note, we say to the defendant, go pay him the debt. But if the defendant demands an oath, saying, take an oath to me, we say to the creditor, go take an oath to him. And if he is a Torah scholar, we do not administer an oath to him. Rav Yemar said to Rav Ashi, can a Torah scholar uncloak people? Does his being a Torah scholar give him the right to collect money the defendant claims he does not owe? Rather, if he is a Torah scholar, we do not attend to his case. The Mishnah teaches that if the claimant said, I have 100 dinars in your possession, and the defendant initially acknowledged the debt, but when he claimed the money the next day, the defendant said that he already repaid him, the defendant is exempt from taking an oath. Rav Yehuda says, the Rav Asi says, in the case of one who lends money to another in the presence of witnesses, the latter is required to repay him in the presence of witnesses. Therefore, if there are no witnesses to the fact that he repaid him, he is liable. Rav Yehuda continues, when I said this in the presence of Shmuel, he said to me that the debtor can say to the claimant, I repaid you in the presence of so-and-so, and they went overseas. The Gemara raises an objection to Rav Asi's statement. We learned in the Mishnah that in a case where the claimant said, I have 100 dinars in your possession, and the latter said to him, yes, and the next day the claimant said to him, give the money to me. If the defendant responded, I gave it to you, he is exempt. The Gemara infers, in here, since the claimant claimed the debt from the defendant in the presence of witnesses, and the latter admitted the debt, he is similar to one who lent him the money in the presence of witnesses. Nevertheless, the Mishnah teaches that the defendant is exempt. Amud Beit. Eventually, he is not required to repay him in the presence of witnesses. Evidently, he is not required to pay him in the presence of witnesses. The Gemara suggests this is a conclusive refutation of the opinion of Rav Asi. So, the Gemara rejects this suggestion. Rav Asi could have said to you, when I said that the debtor is liable to repay him in the presence of witnesses, it was with regard to a case where the creditor lent money to him in the presence of witnesses at the outset, as he did not trust him. But here, he trusted him at the outset, as he lent it to him in the absence of witnesses. Therefore, the debtor is not required to repay the debt in the presence of witnesses. Rav Yosef teaches another version of this discussion like this. Rav Yehuda says that Rav Asi says, in the case of one who lends money to another in the presence of witnesses, the latter need not repay him in the presence of witnesses. But if the creditor said, repay me only in the presence of witnesses, the debtor is required to repay him in the presence of witnesses. Rav Yehuda continued, when I said this in the presence of Shmuel, he said to me that the debtor can say to the claimant, I repaid you in the presence of so-and-so, and they went overseas. The Gemara raises an objection against Shmuel's opinion. We learned in the Mishnah that in a case where the claimant said, I have 100 dinars in your possession, and the defendant said to him, yes, and the claimant then said to him, give the money to me only in the presence of witnesses. Then if the next day the claimant said to him, give the money to me, and the defendant responded, I already gave it to you, he is liable to pay, as he is required to give it to him in the presence of witnesses. The Gemara suggests this is a conclusive refutation of the opinion of Shmuel. The Gemara answers, Shmuel could have said to you that it is a dispute between Tanaim, as it is taught in a Baraita, if the creditor said to the debtor, I lent the money to you in the presence of witnesses, and therefore you must repay me in the presence of witnesses, the debtor must either give him the money or bring proof that he already gave it to him. Rabbi Yehuda ben Beteira says that he can say to him, I repaid you in the presence of so-and-so, and they subsequently went overseas. So, Rav Acha refutes this answer. From where is it derived that the Baraita is referring to a case where the creditor said, at this time of the loan? Perhaps it is referring to a case where he made no stipulation at the time of the loan, but rather said this at the time of the claim, when the debtor claimed that he had repaid the debt. And this is what he says to him. Didn't I lend the money to you in the presence of witnesses? You should have repaid me in the presence of witnesses. But if he made this stipulation at the time of the loan, all agree that the debtor is liable. Therefore, there is no evidence that Rabbi Yehuda ben Beteira agrees with the opinion of Shmuel. In conclusion, Rav Papi says in the name of Rava, the halacha is that if one lends money to another in the presence of witnesses, the latter is required to repay him in the presence of witnesses. And Rav Papa says in the name of Rava, In the case of one who lends money to another in the presence of witnesses, the latter is not required to repay him in the presence of witnesses. But if the creditor says, repay me only in the presence of witnesses, the debtor is required to repay him in the presence of witnesses. And if he said to him, I repaid you in the presence of so-and-so, and they went overseas, his claim is deemed credible. So the Gemara cites several incidents involving loans and witnesses and provides a mnemonic device for them. Reuven and Shimon, who learned halacha, borrowed, and repaid so-and-so and so-and-so gall nuts for a different debt, deeming them credible like two witnesses. Okay, the Gemara relates, there was a certain creditor who said to the debtor, when you repay me in the presence of Reuven and Shimon. The debtor went and repaid him in the presence of two other witnesses from the general public. When the case was brought before the sages, Abaye said, the creditor said to the debtor to repay him in the presence of two people who would serve as witnesses, and he repaid him in the presence of two people. Therefore, the creditor has no further claim. Rava said to him, it is for this reason that the creditor said to him to repay him in the presence of Reuben and Shimon, so that he will not be able to dismiss him by saying that he repaid him in the presence of other witnesses. Okay, the Gemara relates, there was a certain creditor who said to the debtor, when you repay me in the presence of two people who have learned halacha. So the debtor went and repaid him between the two of them, that is, in the absence of witnesses. Those dinars were subsequently taken from the creditor and due to circumstances beyond his control. So the creditor came before Rav Nachman for judgment, and he said to him, yes, I received the money from him, but since he did not repay me as stipulated, I accepted it only as a deposit. I accepted it as an unpaid bailee, not as payment, and said to myself, let it be with me as a deposit until two people who have learned halacha happen to arrive, and the debtor will fulfill his condition. Since the money was taken from me due to circumstances beyond my control, and I had it in my possession only as an unpaid bailee, I am not responsible for it, and the debtor is still liable to repay me. Rav Nachman said to him, since you admit that you certainly took the money from him, it is a proper repayment. For you say that the debtor is still required to fulfill his condition. Go bring the money now, as Rav Sheshet and I have learned halacha and sifra and sifrei and tosefta in the entire Talmud. Let him give you the money in our presence, and the condition will thereby be fulfilled. Since he gave you the money intending to repay the debt, and did not agree to entrust it to you as an unpaid bailee, your claim is not valid. Your claim is not valid. The Gemara relates, there was a certain person who said to another, give me the 100 dinars that I lent you. The latter said to him, this matter never happened. You did not lend me money. The creditor went and brought witnesses who testified that he lent the money to him, and the debtor had repaid him. Abaye said, what is there for the court to do in this case? The same witnesses said both statements, and they said that the creditor lent him the money, and they also said that the debtor repaid him. So Rava said, anyone who says, I did not borrow, is considered like one who says, I did not repay. Since there is testimony that he borrowed the money, and he admits that he did not repay it, he is liable to repay the debt. The Gemara relates, there was a certain person who said to another, give me the 100 dinars that I claim from you. The latter said to him, didn't I repay you in the presence of so-and-so and so-and-so? The two people he mentioned, so-and-so and so-and-so, came and said, this matter never happened. Rav Sheshet thought to say that based on the testimony of the witnesses, the debtor assumes the presumptive status of one who falsely denies his debt. His claim that he repaid the debt is no longer accepted, and he is liable to pay. Rava said to him, anything that is not incumbent upon a person is not on his mind. That is, he is apt to forget. The Gemara relates, there was a certain person who said to another, give me the 600 dinars that I claim from you. The latter said to him, but didn't I repay you with 100 kav of gall nuts? And that is the end of Daf 41.